Okay, so let's unpack this. I want you to imagine a scenario for a second. You're living in this really nice gated community.
Right.
The grass is cut, the security guards salute you at the gate, and the monthly newsletter talks about, painting the walls and fixing the water pumps. It feels normal.
It feels very functional. Like it's the absolute picture of suburban stability. It's exactly what you pay your maintenance fees for.
Exactly. But now, imagine that underneath that fresh coat of paint and the friendly security guards, there is a secret.
A pretty massive secret.
Right. A secret so big that it implies the government has actually revoked the community's legal right to collect a single rupee from you.
Yeah.
They're paving roads, they're paying bills, issuing invoices, but, well, their legal authority to actually touch your money effectively vanished months ago.
It creates this totally bizarre state of existence. It's almost like a zombie government. It's walking around, passing motions, doing things, but legally, it might already be dead.
And that is exactly the situation we are diving into today. We're calling it the governance paradox. And to do this, we're looking at a really fascinating case study from the Vasanth Vihar Army Residents Welfare Association.
Which is such an interesting case.
It really is. We've got two documents on the table that paint two completely different pictures of reality. First, we have the minutes from their management committee meeting. This was held on February 21, 2026.
Which, if you read it in isolation, it reads like a very standard business-as-usual corporate diary. It's full of mundane details about plumbing and painting.
Yeah, plumbing, painting, the usual stuff. But then we have this blistering document that came out just 5 days later on February 26. It's a legally rigorous compliance review of that exact same meeting.
And let me tell you, the difference between what the committee said they were doing and what the law says they actually can do it is night and day.
It's wild. This is a classic, if somewhat terrifying, example of how business as usual can actually become a massive liability trap.
Totally. It's not just about neighborhood gossip. This is a story about fiduciary duty, transparency, and what happens when you completely ignore the legal bedrock of your organization.
So our mission for this deep dive is to figure out how a community gets into this mess in the first place. How do the people in charge end up spending money they might not legally have?
And what does that mean for you, the residents who are just trying to live their lives?
Right. Let's start with the surface layer.
Okay.
If I just handed you the meeting minutes from February 21st and you didn't know anything else, what would you see?
Honestly, you'd see a very active, highly responsible committee. I mean, they're dealing with the nuts and bolts of community management. They definitely aren't sitting on their hands.
No, not at all. First up, they're talking about water. The minutes literally say summer is fast approaching, they're worried about shortages.
Which is a completely valid concern. Managing water scarcity is usually the #1 job for these kinds of associations. And they aren't just worrying, they're taking action. They implemented these water conservation measures in Appendix B.
Yeah, I read Appendix B. It's actually quite detailed.
Oh, it's incredibly detailed. No hose pipes for driveways, no watering lawns during supply times. And my personal favorite, you can't wash your car with a hose. You have to use a wet cloth or a pressure washer.
It feels very disciplined, like
Yeah.
they are really trying to tighten the belt for the community.
It sounds prudent. They're managing resources, and they're sort of deputizing the residents, too. The minutes say residents have the right to stop wastage if they see it happening.
That's a really interesting social dynamic. So if I see my neighbor spraying down his driveway, I'm effectively authorized by the committee to go over and tell him to cut it out.
Basically, yeah. A little community policing to save the collective resource. On the surface, this looks like fantastic governance. They're anticipating a problem, the summer water shortage, and creating proactive rules to solve it.
It definitely shows they're engaged. And they aren't just making rules, they're spending money on infrastructure.
Right.
They approved painting the boundary walls, which is a project worth about 3 lakh rupees. They're servicing transformers for over 1.53 lakhs. They're fixing sewage treatment plant panels for 67,000 rupees.
Exactly. If you were a resident sitting in that meeting, or even just reading these minutes later, you'd think, great, my maintenance fees are actually at work. The transformer is getting oiled, the walls are getting painted, the water is being managed.
It feels reassuring. It feels like the system works.
But that feeling of function is exactly what makes the next part so shocking. Because this is where that legally rigorous review comes in and just completely flips the table.
Yeah.
This document takes that feeling of business as usual and dismantles it piece by piece.
This is the bombshell, segment 2. So 5 days after this highly productive meeting, a legal review drops. And it doesn't care about the painting or the water hoses. It cared about one specific thing that was missing from the minutes.
The elephant in the room, so to speak. The review reveals that there is a final regulatory order, a binding order from the government, that prohibits this association from collecting maintenance fees under its current registration.
Whoa. Okay, slow down. I want to make sure I understand this clearly. The government has explicitly said you cannot collect money.
That appears to be the undeniable case based on the review. It states the order is live. And here is the real kicker. No appeal has been filed against this order, and no stay order has been obtained.
Wow.
So legally speaking, the prohibition is active. It's not a polite suggestion. It's a hard red light.
So when they sent out those bills for February, when they collected the money to pay for the wall painting,
They were arguably acting ultra vires.
ultravires.
That's a legal term meaning beyond the powers. If the regulator says stop collecting and you just keep collecting, you're operating outside the law. You're effectively acting as a rogue entity.
But wait, I went through those minutes twice. I didn't see a single thing about a regulatory order or a ban on fees.
And that is what the review calls the breach of candor. That's the core accusation here. The committee held a meeting, discussed finances, approved spending, and yet nowhere in those minutes did they mention, hey, by the way, the government says we can't collect money.
That feels like a pretty massive thing to leave out. That's not just a minor detail like, oh, we ran out of coffee in the break room. That feels existential.
It is entirely existential. Fiduciary duty isn't just about not stealing money or balancing the books. It's about the duty of candor, the absolute obligation to be honest with the members about the legal state of the association.
Right.
The review argues that by suppressing this material fact, the committee is letting members vote in the dark.
So the members are raising their hands to approve painting a wall, completely unaware that the money to pay for it might be illegal to collect in the first place.
Precisely. The review calls it a governance paradox. You have a committee acting exactly like a government, passing laws, spending taxes when their actual charter to do so has been suspended. They're performing the rituals of governance without the authority of governance.
It's almost like a play. They're just acting out the role of a committee.
Exactly.
Which leads us right into the money. Because even if we ignore the legal issue for a second, the numbers themselves are looking a little shaky, aren't they?
They really are, and this is where the duty of prudence comes in. The association has an income of about 1.87 crore rupees, which sounds like a lot of money.
It does.
But when you look at the expenditure, they are projecting a deficit of over 5 lakh rupees for the year.
So they're in the red.
They're running a clear deficit. And normally, how do you fix a deficit? You collect more fees or you cut costs. But here, they made a decision that the legal review flagged as incredibly dangerous. They decided to break a fixed deposit.
I saw that in the minutes. A Canara Bank FD.
Right. A principal amount of nearly 16 lakh rupees, 15 lakh, 94,744 rupees to be exact. They are liquidating long-term savings.
And what are they spending it on? I mean, is it a life or death structural emergency?
According to the minutes, it's to pay for the repainting of MSB, Pocket 3.
So, cosmetic upgrades.
Purely cosmetic.
Let me get this straight. They are burning their savings account to paint a building at the exact same moment that a court order says they cannot collect new money to replenish those savings.
That is the textbook definition of a breach of the duty of prudence. Prudence means you act with caution, especially with other people's money.
Right.
If your income stream is legally cut off, the prudent thing to do is freeze all non-essential spending. You don't break the emergency fund to paint the walls. You batten down the hatches.
It's like losing your job and then immediately cashing out your retirement fund to buy new siding for your house.
Exactly, while hiding the fact that you lost your job from your spouse.
Oof. Yeah, that really puts it in perspective. But here's the thing. They are trying to get money, right? The minutes show they are very heavily focused on revenue collection.
This is where we get into a major legal trap. The committee is in a bind. They have expenses, the painting, the transformers, so they need cash. The minutes show they're instructing pocket secretaries to personally reach out to members to aggressively demand the outstanding monthly maintenance charges.
They're really chasing those payments down.
They are. But connect this back to the regulatory order. If the association is currently prohibited from collecting maintenance, then technically those maintenance charges aren't legally enforceable debts at this moment.
That is a massive problem. You're demanding people pay a bill that you aren't actually allowed to send.
Exactly. The review points out the immense legal exposure here. If you aggressively demand money you have no right to collect, you are opening the door to civil liability. You are acting as a debt collector without the debt being legally valid.
It creates such a strange dynamic. The committee is acting like this strict enforcer of the rules, pay up, while they're simultaneously breaking the biggest rule of all, which is the government order to stop.
It creates a huge fracture in the community. You have the residents who just pay because they trust the system, and the residents who might know about the order and refuse. And the committee is caught in the middle, trying to force compliance to keep the lights on, but doing so on incredibly shaky legal ground.
And while all this financial drama is happening, they are still trying to aggressively control how people live. Which brings us to operational overreach. I have to talk about the pets.
Ah, yes, Pocket 3.
The one pet per apartment rule. The proposal in the minutes was incredibly specific. It cited, and I'm not making this up, Lebensraum.
Lebensraum, that is a very loaded term. It translates to living space, but historically it has some very heavy baggage from the mid-20th century.
Yeah, to put it mildly.
It's a very strange word to find in the minutes of a housing society meeting in 2026.
It says, due to limited Lebensraum in the lifts and complex, they are mandating a strict one-pet limit. They cite a dog bite incident from January 29th as the justification.
But here's the problem. The legal review points out that resident welfare associations generally cannot impose blanket bans that are inconsistent with Supreme Court rulings.
Right.
The courts in India have been very clear. You cannot ban pets, and you cannot enforce arbitrary limits like one dog only unless strictly aligned with animal welfare laws.
So they're passing rules that might get struck down the moment they're legally challenged.
Highly likely. It's just another example of acting without checking the legal boundaries. They're asserting authority over people's private lives, literally telling them how many cats they can have while their own authority to exist as a board is under question. It's a desperate grasp for control.
And it wasn't just pets either. There was something about maids and security passes, right?
Yes, over in Pocket 4, there was a concern raised about domestic help using potentially fake Aadhaar cards or illegal documentation, which is a valid security concern.
And the committee's response to this was status quo to continue.
Which the legal review immediately flagged as imprudent. If the association is collecting Aadhaar cards and issuing passes, they are processing sensitive personal data.
Right, data privacy is huge now.
Exactly. Under the new DPDP Act, the Data Protection Act, and the Aadhaar Act, you have strict responsibilities. You can't just collect ID cards loosely.
So by saying status quo, they are basically ignoring the new privacy laws.
They're ignoring a massive compliance risk. They're collecting data without demonstrating clear privacy protocols, which exposes the association to heavy penalties. It's another instance of governance manipulation, just ignoring the complex legal reality to keep things moving along because it's easier than actually fixing the compliance issues.
It really feels like they're driving a car with a suspended license, speeding and texting all at the exact same time. So what happens when they inevitably crash? Because this can't go on forever, right?
The legal review outlines what it calls a liability cascade, and it is genuinely terrifying for anyone who owns a home in that community.
Walk me through the worst-case scenario.
First is refund liability. If the courts decide that the collection of fees was illegal during this whole period, the members could sue to demand their money back.
All of it.
Potentially all of it, plus interest. And remember, they've already spent a lot of it on painting walls and fixing transformers. So where does the refund money come from?
The residents?
Ironically, yes. The association has no money of its own. It's just a pass-through entity. So to refund the members, they'd have to assess the members. It creates a complete financial black hole.
Unless, wait, is there another way?
Unless the courts hold the office bearers personally liable. That's where the duty of legality comes in.
Oh, wow.
If you act completely outside your authority, the corporate shield, the thing that usually protects volunteer board members from personal financial risk, might not protect you. If I'm the president or the treasurer, and I signed checks I wasn't allowed to sign because of a government order, I could be paying out of my own pocket.
That is an absolute nightmare scenario for a community volunteer.
And then there's the registrar, the government body actually overseeing all this. They could step in and suspend the committee entirely. They could appoint an external administrator to take over. That means the community completely loses its right to self-governance simply because the leaders refuse to follow the rules.
The review called it a compliance gap, but honestly, listening to you lay this out, it sounds a lot more like a canyon.
It creates that zombie organization we talked about at the start. It's walking and talking, painting walls and checking water pipes, but legally, the entire foundation has rotted away.
It really makes you rethink the whole concept of business as usual. We value it, right? We like it when things run smoothly. We like when the newsletter comes out and the walls look nice. But this deep dive shows that sometimes business as usual is just a really effective way to hide a massive crisis.
It's the difference between a house that looks sturdy and a house that actually is sturdy. A fresh coat of paint doesn't matter one bit if the foundation, the legal authority, is cracked. And often we don't bother to look at the foundation until it's far too late.
So we've unpacked the meeting, the paradox, the missing money, and the risks. Let's wrap this up. What is the absolute main thing you want people to take away from this?
The big takeaway for me is the duty of candor. Transparency isn't just a corporate buzzword, it's an actual legal shield. If the committee had just said, hey everyone, we have this regulatory order against us, let's figure it out together, they'd be in a tough spot, sure, but a safe one. By hiding it, by pretending everything was perfectly normal, they turned a manageable legal problem into a potential catastrophe.
They tried to paint over the cracks, quite literally.
They did, and now the paint is peeling.
So here's a final thought for you to chew on as you go about your day. We talked about the internal risks, but what happens when the outside world finds out?
Right.
Imagine you're a resident trying to sell your apartment. The buyer's bank asks for a routine, no objection certificate from the association. But the association legally can't issue one because their authority is suspended.
That would freeze the sale instantly.
Exactly.
Hmm.
Or what if the vendor hired to paint the walls discovers their contract was signed by a legally suspended entity? Do they walk off the job? Do they sue the individual board members? The blast radius of a governance paradox doesn't just stay inside the community walls. It bleeds into your property values and the local economy.
That is the ultimate cost of keeping people in the dark.
It really is. Thanks for joining us on this deep dive. Keep asking the tough questions, check your own association's minutes, always read the fine print, and we'll catch you next time.